SJC-12704, Commonwealth v. Angel Camacho.
Mr. Malm, good afternoon.
Good afternoon, Your Honor. May it please the court, Matthew Malm for the defendant, Angel Camacho. There are two issues in this case. The first issue is the enforceability of a collateral review waiver in a plea agreement. And the second issue is the retroactivity of this court's holding in Bridgman 1. I intend to address these issues in that order. This court should declare all waivers unenforceable because they violate public policy. This is because if they proliferate, they have the potential to insulate the vast majority of criminal cases from appellate review. This would seriously impede this court's ability to correct errors, ensure that the law is applied uniformly, and develop the law.
Now, is this the case in which we need to resolve it? Because at least from my reading of the Commonwealth's brief, I don't know that they seek to ask us to do that.
So the Commonwealth's brief focuses on the merits of the underlying merits of the case, but that is not properly before the court because the court below never addressed the merits. She only decided this case based on the waiver. She never got to the merits, so there's nothing for the court to consider in that respect.
Well, there is even if we don't reach that issue, there is the question of what degree of retroactivity, but I guess that's part two, I guess. Okay.
And I'll get there shortly, but just before I get to that point, I want to make one last point about the waiver. Even if the waivers do not become widespread, they still pose a significant threat because they allow the Commonwealth to screen out cases at the trial court level that might raise significant appellate issues.
And are you arguing this for all criminal cases or only a certain category of cases under Bridgman or just all waivers with regard to how this is done?
Yes, so my waiver argument, I'm asking for all waivers, and it tied to any plea. In my brief, I give some more case-specific ways to resolve this issue without addressing the larger issue. I think the second best option would be to create a voluntariness exception to waivers and just treat waivers as part of a plea agreement. If you're challenging the voluntariness of a plea agreement, or if the plea agreement's involuntary for any reason, so is the waiver.
Have we had these collateral review waivers in other cases other than these?
I've only found one other published case, that's Commonwealth v. Pike from the appeals court, and they really didn't address the question. It was a little different facts, and it was a waiver of direct appeal in a related case. So the defendant there had been convicted, and then on another case, I believe the conviction after trial was for abuse of one of his children, and there was another case, a trial coming up for abuse of another child, and so he pled guilty to that second case, and tied into that was a waiver of direct appeal of that first case.
I guess my concern is that you're asking us for a solution in search of a problem, and we don't really know. First of all, it doesn't sound very frequent, and we don't know to what extent that defense attorneys can utilize these waivers to help them in negotiations. That may be in 0 cases, but we don't know. And without some sort of case about that, I mean, your other point sounds like a good one. If the plea's involuntary, then the waiver might well be involuntary. That makes all the sense in the world. But to come up with some sort of systemic solution as to collateral review waivers when we don't have a problem, it doesn't seem to make sense.
And of course, the defendant would be happy with the voluntariness exception because that would apply directly to his case because he's challenging the voluntariness of his plea. But I think the threat is real from waivers, and that's the fact that even if they don't become prolific, the Commonwealth can still use them without any detection from this court to screen out cases it sees potentially significant appellate issues it doesn't want to deal with.
It can also null-process a lot of things too, right? I mean, if they don't want issues to reach the court.
Yes, but the defendant isn't really giving up anything in exchange for the null process. I think it's not an appropriate analogy.
Can you, just a fundamental question, how does I understand he's got a new federal case, and that's why you're here. But how does he get any better than time served?
So if he could have rejected the plea deal,
Right.
and perhaps he could have negotiated a better deal with something.
How much better could he have done,
Well, he could have. He was
other than an apology?
it was okay. So he was charged with trafficking,
Right.
among other things. He
Like
got
trafficking like 200 grams.
He got distribution. He could have perhaps gotten possession if he was in a better position, if he had the benefit of Bridgman. And he also could have.
He comes in, and I know you argue the waiver, but they had given him a sentence which exceeded what he had, and then he comes in on that day and he says, well, basically, we'll give you time served, walk away, and he takes it.
And he also, if he rejected the plea deal, he could have gone to trial and been acquitted.
If we could turn to the issue of retroactivity, I'm probably the only person on this court, maybe Justice Lenk, who was here for Bridgman 1. I think we would have been concerned if we had found a case done earlier in which the person received a sentence that was above what the person had initially gotten, despite the Dukin violation. But I don't know that we thought that we were going to open the door to every person who made a plea before Dukin now saying, well, now the plea was involuntary because I did not know that I was not facing the maximum potential sentence and was only facing an upper limit of the previous sentence. Is it your view that we did open the door to every plea now making the argument that you're now making?
Okay, so the short answer is yes, and it's limited to Dukin defendants who withdrew their plea, after learning about Dukin's misconduct and before Bridgman. So it's fairly.
It's a lot of folks.
And so the door was left open because this court didn't rule either way on whether it would be retroactive, and it's completely within this court's discretion to make. It was an exercise of its superintendent's power, and that's completely within this court's discretion to apply that retroactively or prospectively only. And the defendant is aware that retroactively applying a superintendent's power is unprecedented, but so is Dukin's misconduct. And it presents a unique case in where retroactivity is uniquely appropriate.
If it's discretionary, why can't we say, well, we will apply Bridgman 1 to any defendant who actually received a sentence above what he had or she had earlier gotten, but we're not going to apply it to those who did not?
Because there's still harm to people who, like Mr. Camacho here, who was faced with a choice between the plea deal he was offered and going to trial where he was facing up to 22 and a half more years. So he suffered prejudice there because his choice was skewed by Dukin's misconduct, essentially.
What about all the people who pled guilty before the drug certs were issued?
Well, I think that is at Cotto, or I believe, I think, so that doesn't, so that wouldn't apply to them. I think because.
We didn't make it retroactive to them. They in every case we issue, we said if you pled guilty before you knew the discovery, you pled guilty.
So I think
Our guy pleads guilty knowing that the issue is up in the SJC, and they say you get time served. He decides to roll the dice, and he gets time served.
So the question is how you should treat people who pled guilty before they got the drug certs back.
Well, we know how we treated them. We didn't give them any relief.
Yes, and so that.
So why should your client be in a better position than those folks?
Because he didn't plead guilty until after so he's distinguishable from the Cato category of defendants in that respect.
So if you're right, you would have to remand the case to this particular, or to a Superior Court judge, because this Superior Court judge did not reach the issue of prejudice.
Yes, Your Honor.
You may not like your chances, but you'd still be entitled to a remand.
Yes, Your Honor.
So if we do what you want, we open the door to remanding all these cases whenever anybody brings these matters before us.
So you would be opening it up to similarly situated defendants, so Dukin defendants who pled guilty, who withdrew their plea and resolved their case before Bridgman was decided.
And I guess the question is balancing
So,
balancing the risk of unfairness against the burdens that would place with regard to remand. Why should we do that?
and that goes back to the uniqueness of the Dukin situation, which, to cite language from the Bridgman case, is a defendant who files a motion to withdraw a guilty plea as a consequence of Dukin's misconduct is not doing so in the context of an ordinary case. It is the product of an egregious and systemic lapse entirely attributable to the government.
Unfortunately, it wasn't so unique, right?
So we have Farrak as well now, is what you're referring to. I guess, I still think it's unique. I think there are hopefully many more drug lab chemists who are
Right,
doing the job
hopefully
correctly.
that's it, but right, I understand your argument. It is, I agree with you, it is unique misconduct.
Do we, have we, I'm trying to think back to the Dukin and Farrar cases, how much of it was, did we exercise our superintendent's authority retroactively? All those cases, of course, were passed, so there's a certain retroactivity inherent in what we did.
Yes, so I think Scott is a good example in that you're retroactively applying this new misconduct that was found to the pleas. Looking at a hypothetical plea essentially, and what would it be if they had known? And it's really the same thing here. What would it have been if Mr. Camacho had been facing 22 and a half years?
Okay, thank you.
Thank you.
Mr. Lesson? Is it Leeson or Lesson?
Good morning. Ian Leeson,
Leeson, okay.
Assistant District Attorney representing the Commonwealth. And I ask that the court affirm the motion judge's decision because the defendant did not raise a substantial issue of involuntariness. This court also should, as Chief Justice Gantz was inquiring about, give us some guidance here, because the court can decide, as the Commonwealth is frankly assenting to, not asking you to enforce this particular waiver in this particular case. It doesn't meet his claim of his plea not being knowing and involuntary. It doesn't meet that. In this case, we can address really the merits of what kind of the thrust of what his argument is. But we need that guidance because all along, this court in this line of drug lab cases has created sui generis rules and remedies, and that's why we do need the guidance. We can't guess. So he suggests, while no one can really argue that the terms of his 2013 plea were perfectly consistent with what eventually became known as the Bridgman cap 18 months later, and that is that the simple fact that the sentence he received was less than, from 6 to 8 years, down to 3.5 years to 3.5 in a day, and the charge itself was less, from trafficking cocaine, 28 grams or more, down to possession with intent to distribute. Nobody can argue, no one, that it didn't square with Bridgman. He's still arguing, and again, it's the essence of his claim that his plea was involuntary, that Bridgman 1 can still do something for him, that it should be applied retroactively somehow. The only thing left, and really if we look at his argument, he is claiming that he should have been advised 1.5 years before Bridgman. He should have been advised that the maximum he was facing was the 6 to 8 he took the first time around.
So if he had said, I want to go to trial again, and he had gotten the mandatory for 28, I'm sorry, for I guess more than 200 grams, would it be fair to allow him to serve the mandatory, whatever it is, 10 or 12 or 14 years?
No. In that
So-
situation, the court should apply, should we see that situation, should apply Bridgman
Ceiling
retroactively.
6 to 8.
Right, so you're saying we should apply Bridgman retroactively where the sentence, in fact, that was imposed did exceed the earlier sentence?
I would say so, yes, more than what the court needs to decide to resolve this case, yes, but should those defendants exist? If someone comes forward, we also frankly wouldn't be here. If someone came forward in that situation, we would make it right. Now, the reason that that's the
In
case.
in your office, but that may
Well-
not be the position of every DA's office.
Well, it isn't. What I can say is the reason that should happen is because this court should let us all know it is right, not because it squares with traditional retroactivity analysis. It doesn't. The Bridgman cap rule was new. That was the point, is that the legal landscape was scaring people away from the courthouse. And along the line of these drug lab cases, the court has told us things that were counterintuitive. And if we were to see that situation, the court should let a defendant know you're going to get relief. However, what the defendant here is asking for is that it's stretching it too far. And it's important to know what the court said in Scott and Bridgman 1 and all along was this governmental misconduct is not to be shouldered by defendants. And no one can dispute that. But all of the rules have been measured all along, and everything the court has done. Charles, Scott, saying there are two prongs, you get one. Bridgman 1, the idea of the cap is your exposure is limited. You're going to be able to litigate these rights. But, and even by Bridgman 2, where the court says explicitly what we're doing 4+ years on, it's respecting prosecutorial discretion. And this entire framework tells the defendants, you can still be prosecuted. You don't get this relief without legal grounds, in this sense, what he's asking for. You can possibly lose your motion to vacate. You may be convicted again at trial. You may do time, but your exposure is limited. And even in Bridgman 2, again, where the court rightfully said enough, and the protocols were put into place, that language is there. We're balancing situations.
All those carefully drafted waivers, we should just ignore those and just decide the case in that way?
They should not be ignored. There are situations where those waivers would apply, and the Commonwealth would say, this does meet your argument head on. An example to allude to what Your Honor mentioned, in paragraph 2 of that waiver, which is essentially, it's not limiting, it's not saying you can only come forward if this would bar you if you only came forward with information about the lab. We see these motions, if someone came forward today with a Duke insert or a Hint insert of any kind and said, well, Sonia Farrak was very bad and Amherst was very bad. We know that Sonia Farrak spent a year at Hinton, summer of 2003 through summer of 2004. Therefore, I'm moving to vacate my guilty plea. That is a situation where that waiver would meet it squarely, and the Commonwealth would say, we're opposing this motion. Also, to address the defendant's very broad request about collateral review waivers, 10 pages spent in this brief suggesting that the Commonwealth is looking to do away with this building, essentially, all told. That's obviously not what the Commonwealth is doing, and it's certainly more than the court needs to decide the case. Finally, it's important to note that even if we, just for the sake of argument, if we take the defendant's position and we follow him all the way down that path to the logical endpoint of what he's asking for, if we forego retroactivity analysis, if we say, for the sake of argument, we'll apply Bridgman 1 to your case, even in the novel way you're asking for the sake of argument, you should have been advised in 2013 of Bridgman, which was a year and a half away. Even if we do that, a judge's failure to advise a defendant of the maximum penalty at a plea does not provide grounds to withdraw the guilty plea. And this is a line of cases started in 1978 with Curry, 1981 with Kavanaugh, where the court there said, Rule 12, you have to comply with it. It's a requirement. At the same time, a judge's failure to do so. And again, just a hypothetical, if we take him all the way to the end of his argument, if a defendant is not told what the maximum is, it's harmless beyond a reasonable doubt. And that was the case in Curry and Kavanaugh, where the court said, because this was actually an agreed upon tender, which was the case here, the maximum, he didn't hear about the maximum, he didn't need to. Harmless beyond a reasonable doubt. And later in 2001, the appeals court in Luis Rodriguez, Murphy in 2008, And even just last year, November of 2018, in a Rule 128 decision, Commonwealth v. Stacy, this principle was upheld repeatedly. If you got less than the maximum and you have nothing else to show other than, well, I wasn't told the maximum, that's not grounds to withdraw your guilty plea. So all of that said, again, I would ask the court certainly to rule on this here. I can make the arguments about it would be convenient and efficient, and you can rule on what's supported by the record here, and I do make those arguments. But more importantly, let us know in this context where it's been a lot of sui generis rules, let us know, as Your Honor alluded to, we'll just keep seeing these motions. It's very narrow ultimately, but defendants who came forward with a Dukin conviction in between September of 2012, when the news broke, through May of 2015, when Bridgman 1 was announced. If you came forward and you resolved your case and you were sentenced to less than you were the first time around, and/or a lesser charge than you were convicted of the first time around, there's really no relief to be had by asking for this sort of novel, retroactive application of Bridgman, where you're supposedly, you should have been advised of the Bridgman cap in this clairvoyant way before it was announced. So ask the court to affirm the motion judge's decision. If there are no further questions, I'll rest on my brief.
Okay, thank you.